On the record in the matter of James Olney versus Justin Batterson, file number 23-03585, council appearance.
Please court, Your Honor, Attorney Frank Narrett for the plaintiff, Mr. Olney.
And good afternoon, Alyssa Hull with Legal Services of South Central Michigan for defendant Justin Batterson.
Good afternoon, Your Honor. Justin Batterson is here as well.
Thank you. Okay, today was the date that was scheduled for a hearing on a non-payment of rent. My understanding is that there was a conditional dismissal. Is that correct?
That's correct, Your Honor. I'll defer to Ms. Hull.
Yes, it is, Your Honor. We reached an agreement where Mr. Batterson will vacate the premises and return the keys on or before April 30th of 2024. This was submitted through my file, I believe on Tuesday or yesterday.
Mr. Batterson, is that correct?
Yes, Your Honor.
Okay. And Mr. Batterson, you understand that you do have the right to proceed to a trial in this matter, and you have the right to demand a jury trial, correct?
Yes, I do, Your Honor.
However, you want to have this matter resolved by you entering an agreement whereby the case will be dismissed today upon the condition that you vacate and turn over the keys no later than April 30th of 2024. Is that accurate?
Yes, Your Honor.
You also understand that partial performance is not going to satisfy this agreement. So by vacating, you must remove all of your personal items and have the property left in broom swept condition. You recognize that?
Yes, Your Honor.
Okay, otherwise, if you don't follow completely as you are agreeing to, the plaintiff can request judgment to enter against you immediately without giving you a notice of a new hearing. Okay?
Yes, Your Honor.
And the court will review and sign your conditional dismissal that was filed electronically. Mr. Batterson, you have 3 business days from today's date to return to the court. If once you leave here, you realize you misunderstood the right that you waive, which is your right to a trial, and you can return and have this agreement set aside. We'll set it for a hearing, okay?
Yes, Your Honor.
Do you have any questions for the court?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing further, Your Honor. I want to thank you and your staff for allowing us to appear virtually. Appreciate it.
No problem. No problem.
I appreciated that as well, Your Honor. That is very, very considering, and we appreciate it.
No problem. Thank you both.
Thank
Have a
you.
good one.
You as well.
On the record in the matter of the people of the state of Michigan versus Dennison Jones, file number 24-01130. Appearance for the record.
Assistant Public Defender John Lee appearing on behalf of Dennison Jones, Your Honor.
Okay, you're Dennison Jones.
Yes, Your Honor.
Okay, Mr. Jones, today's the date and time scheduled for an arraignment. I do have before me a felony complaint that was being reissued against you. The allegations are that on or about February 8th, 2024, at the area of Malibu Drive and Continental Drive, which is in the city of Lansing, Ingham County, state of Michigan, that you did allegedly, contrary to law, commit the act in count 1 of assault with intent to do great bodily harm, less than murder, or by strangulation. The allegations are that you did make an assault or assault and battery upon a Quavatus Jacobs with the intent to do great bodily harm less than the crime of murder, contrary to Michigan Compile Law 750.84. Count 1 is a felony, and the maximum penalty is 10 years in prison or $5,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Count 2 is reckless driving causing serious impairment of a bodily function. The allegations is that you did drive a vehicle upon a highway, that being Malibu Street, at or near South Waverly, Lansing, in a willful or wanton disregard for the safety of persons or property, and by the operation of that vehicle did cause serious impairment of a body function of a Quavatus Jacobs, contrary to MCL MCL 257.6263. Count 2 is a felony with the maximum penalty of 5 years in prison and or $1,000 to $5,000 in fines, and vehicle immobilization is mandatory unless the vehicle is forfeited. Reimbursement to the government for emergency response and expenses for prosecuting the defendant may also be ordered. Count 3 is police officer fleeing a 3rd degree under the penal code that alleged that being the operator of a motor vehicle to whom was given a visual or audible signal by hand, voice, emergency light, or siren by Officer Anthony Dean, a police officer who was in the uniform, and the officer's motor vehicle was identified as an official police motor vehicle acting in the lawful performance of his duties, directing the defendant to bring his motor vehicle to a stop, did willfully fail to obey such direction by increasing the speed of the motor vehicle or attempting to flee or elude the officer in an area where the speed limit was 35 miles per hour or less, contrary to Michigan Compiled Law 750.47983. That is a felony, maximum penalty 5 years in prison and or $5,000 in fines. The Secretary of State shall suspend your operator's or chauffeur's license, and for a vessel privileged to operate shall be suspended for a period of not to exceed 5 years. Count 4, assault with a dangerous weapon, also known as felonious assault, alleges that you did make an assault upon a Cravon horn with a dangerous weapon, that being a motor vehicle, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. Now, this was contrary to MCL 750.82. That is a felony. Maximum penalty is 4 years and or $2,000 in fines. Your DNA is to be taken upon arrest. A consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. There is a count 5, assault with a dangerous weapon, also felonious assault, alleging that you did make an assault upon a Jahamer horn with a dangerous weapon, that being a motor vehicle, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder. Again, count 5 is also a felony, maximum penalty 4 years and or $2,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charges read in counts 1 through 5 and the maximum penalties attached to each?
Yes, Your Honor.
Okay, you have the right to be represented by counsel. Mr. Lee is representing you today from the Office of the Public Defender. You have the right to have an attorney represent you at each stage of the criminal prosecution and to represent you if you are questioned by law enforcement. If you cannot afford to hire an attorney, you can make a request to have the Public Defender's Office appointed to represent you at the expense of the public. Do you understand your right to counsel?
Yes, Your Honor.
You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You can plead guilty, plead not guilty, or stand mute. If you stand mute, this matter will proceed to a jury trial. You are being charged with felonies, and in each felony count, you have the right to a preliminary examination. You have the right to have that examination within 21 days of today's date. When I say today's date, I mean the date that you're being arraigned. That timeline of 21 days is yours by right unless you waive the timeline or the court finds good cause to go beyond that 21 days. You're currently scheduled for probable cause conference before Judge Cynthia Ward, April 26, 2024, 9 o'clock in the morning. You may appear via Zoom for the probable cause conference. You have a preliminary examination before Judge Ward Friday, May 3rd, 2024, 8:30 in the morning. You must appear in person for the preliminary examination. Did you get your notice to appear for those dates and Zoom instructions for Judge Ward?
Yeah, I have the paper, Your Honor.
Okay. At the time of your preliminary examination, you have the right to require the prosecution to put forth evidence to establish whether or not they have sufficient probable cause that a crime was committed and then probable cause sufficient to charge you with the crime. You have the right to proceed to a trial. You have the right to jury trial. You have the right to the presumption of innocence. You're innocent until proven guilty. You have the right to require the prosecutor prove your guilt at your jury trial by proving each element of the charges being brought against you beyond a reasonable doubt. You can remain silent at your trial and not have silence be used against you, or you can waive your right to silence and you can testify on your own behalf or subpoena witnesses to your trial to testify for you, or present evidence at trial that you believe show a defense to the charge being brought against you. You also have the right to be considered for pretrial release from custody. We'll address your bond in just a moment. Mr. Lee, is he requesting court appointed counsel?
Yes, he is, Your Honor.
The court will enter a plea of not guilty on your behalf at this time. What's your current home address?
It's 2909 Cabot Drive, that's CABOT. Lansing, Michigan, 48911 is the zip code.
Are you employed?
Yes,
Where are you employed?
it's DEFY, and that's Lansing. It's a trampoline park.
What's your phone number?
I don't know.
Why don't you know your phone number?
Can you say it again, Your Honor?
Why do you not know your phone number?
Oh, my phone number? I'm sorry. It's 517-281-3810.
3810.
Yes.
Are you currently on probation or on parole?
No, Your Honor.
Do you have any court cases pending other than these?
Yes,
Where?
I believe in, is it circuit court?
Do you have a case pending in circuit court?
Yes.
What's the charge?
I'm not sure. I don't have all this stuff in front of me.
When's the last time you've been to court?
I have an upcoming court date next month, but the last time I couldn't tell you because it's been so long.
Mr. Lee, do you have any information about his upcoming court case?
I do show that he has a hearing scheduled for May 8th. And that he is facing a charge of assault with intent to murder.
At circuit court, the 30th Circuit Court?
Yes, my well, that I'm not clear on. Let me double check. His bond was $35,000, 10%. And
9/15/2022. I'm trying to understand why it's not showing up on his criminal record. So what's the date of incident? Okay. What is the charge?
Now it's just a solid attention.
Attempted murder. Yeah. Okay, you can address bond counsel.
thank you, Your Honor. Mr. Jones is on a tether. When his case was dismissed, he went home. He was home for 3 days and enjoyed the support of his family. He has no criminal record other than the matters that are pending right now, and tells me that that's what he would do if he was able to make a bond. We're asking the court to consider some type of a 10% bond on his behalf, that he might have an opportunity to do that, Your Honor.
Okay, he's on tether for the matter before Judge Aquilina. For whatever reason, that's not a matter that's indicated on his criminal history that was provided to me. I see a matter from a date of incident 9/9/2022, but I think the matter that he is on a tether for as a date of incident for May of 2022. Let's see. I don't see any convictions on his record, but there are multiple, and I mean multiple, charges of either a felonious assault with intent to do murder or assault great bodily harm. So that is a concern for the court as it relates to these new charges. I recognize these are being reissued. There was a dismissal in this. Do you have any understanding, Mr. Lee, as to why they were previously dismissed?
My understanding is gleaned from my discussions with Mr. Jones, and I think that the complaining witness failed to appear or participate, Your Honor.
Okay, because he's already out on bond and this is a reissue, the court doesn't believe that there's a continuing concern about flight or a risk to public safety that could not be abated by him already being on a tether. The court will issue a bond of $10,000 personal recognizance. While out on bond, you need to report to all of your future court dates. Do you understand that?
Yes, Your Honor.
Okay, you're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess any drugs or alcohol without a valid prescription. You're not to have any contact, directly or indirectly, with the alleged victims. Quavatus Jacobs, that also includes Anthony Dean, Pavan Horn, and Jahamir Horn. Do you understand that?
Yes, Your Honor.
Okay, so no contact means both physical contact, verbal contact. You can't text or have anybody else communicate in writing to them on your behalf either. You recognize that, correct?
Yes, Your Honor.
You're not to be within 1,500 feet of wherever they are, and because you're already on tether, I'm going to add that condition to your GPS tether, okay?
Okay, Your Honor.
You're not to travel outside the state without prior approval of the court. You're not to use, purchase, or possess a firearm or any other dangerous weapon. You must report to pretrial services within 48 hours of your release. And you should have gotten information from the court as to how, from the jail as to how to report to them. But because you're already on bond, I'm positive you know how to report to pretrial services. Is that correct?
Yes, Your Honor.
Do you have any questions for the court at this time?
No.
No questions, sir? Mr. Jones?
No, I don't have any questions, Your Honor.
Okay, very good. Any additional matters for the record, counsel?
Nothing further, Your Honor.
Thank you. You're all set, sir.
Thank you, Judge Simmons.
Have a good one. You all been doing this? Page 53? Okay, because it does not have all of them.
We're gonna add the two
Okay. It doesn't have all the victims' names. Absolutely. There's 4. Their names are on the complaint. And each count. Okay, on the record, in the matter of the people of the state of Michigan versus, is it Deshar Harris? File number 24-01037. Council appearance.
Thank you, Your Honor. Assistant Public Defender John Lee appearing on behalf of Deshar Divine Harris.
Are you Deshar Harris?
Yes, ma'am.
Okay, Mr. Harris, today's the date set for an arraignment. I have a felony complaint here. It alleges that on or about November 28th, 2023, at the area of 2228 Westbury Road, which is in the city of Lansing, Ingham County, state of Michigan, that you did allegedly, contrary to law, commit the act in count 1 of assault with intent to do great bodily harm, less than murder, or by strangulation. The complaint alleges that you did make an assault upon a Rosalind Tucker by strangulation or suffocation, contrary to Michigan Compiled Law 750.84. That's a felony with a maximum penalty of 10 years or $5,000 in fines. Your DNA is to be taken upon arrest, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Count 2, also assault with intent to do great bodily harm, less than murder, or by strangulation, again alleging that you did make an assault upon a Rosalind Tucker by strangulation or suffocation. Again, that's a felony. Maximum penalty 10 years in prison or $5,000 in fines. Count 3 is interfering with an electronic communication causing injury or death. The allegations are that you did willfully or maliciously prevent, obstruct, or delay by any means the sending, conveyance, or delivery of an authorized communication by or through a telephone or telephone line, and the incident to be reported resulted in the injury or death to a Rosalind Tucker, contrary to MCL 7505405B. That's a felony with a maximum sentence of 4 years and or $5,000 in fines. Count 4 is domestic violence. It alleges that you did make an assault or assault and battery upon a Rosalind Tucker, an individual with whom you had a child in common and or resident or former resident of your household, and or an individual with whom you had a dating relationship, contrary to MCL 750.812. This is a misdemeanor with a maximum penalty of 93 days in jail and or $500 in fines. And again, a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge or charges read and the maximum penalty attached to each count? Okay, you have the right to counsel, and Mr. Lee is representing you today for the purposes of your arraignment only, but you do have the right to have an attorney represent you at each court appearance during this criminal prosecution. And you also have the right to have attorney represent you if you're going to be questioned by law enforcement. If you can't afford to hire an attorney, you can request to have the public defender's office appointed to represent you. Do you understand your right to counsel?
Yeah.
Can you repeat that?
Yes, ma'am.
Okay, you have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You can plead guilty, you can plead not guilty, or you can stand mute. Understand that if you stand mute, the matter will proceed all the way to a jury trial. You have the right to jury trial and you have the right to the presumption of innocence. But before your jury trial, you have the right to have a preliminary examination. And you have the right to have that exam within 21 days of today's date, unless the court finds good cause to go beyond the 21 days or you waive the 21 days. You're currently scheduled for a probable cause conference before Judge Michael Anthony Flores. It's going to be on April 25th, 2024 at 8:30 in the morning. And then you have a preliminary examination before Judge Flores, May 2nd, 2024 at 8:30 in the morning. You must appear in person for your preliminary examination. Did you get a copy of your notice to appear before Judge Flores and Zoom instructions?
Yes, yes, ma'am.
Okay. You have the right to have the prosecution at the time of your preliminary examination put forth evidence that would establish probable cause sufficient that a crime or the crimes alleged in count 1, 2, and 3 were committed, and that those crimes were allegedly committed by you. Do you have any questions about your preliminary examination?
No, ma'am.
At the time of jury trial, you have the right to remain silent and not have silence be used against you. You have the right to cross-examine or question any of the witnesses in court called to testify against you. You have the right to call your own witnesses or present evidence that you believe show a defense to the charges being brought against you. You also have the right to remain silent and not have that silence be used against you, or you can waive your right to silence and testify on your own behalf at your trial. Do you have any questions about those rights?
No, ma'am.
Is he requesting court-appointed counsel?
Yes, he is, Your Honor.
Or will enter a plea of not guilty on your behalf. Mr. Harris, what's your home address?
3622 Birchfield Avenue, Lansing,
you to start-
Michigan.
I need you to start from the beginning, but I need you to speak as loud as I'm speaking.
Okay, 4622 Birchfield Avenue, Lansing, Michigan, 48910.
Are you employed?
That's
Where?
Great Lakes Janitorial and Myers Warehouse.
What's your phone number?
313-604-8785.
Are you currently on probation or on parole?
No.
Do you have any other court cases pending?
Yes, I have to come back here the 23rd, in front of Mr. Flores for hindering and opposing.
Judge Flores?
Yes. For hindering and opposing and trespassing.
Do you have any other cases pending?
Yep, and I had one in Clinton County. I'm pretty sure.
I need you to speak louder because it's not picking up your voice.
And I had one, I think I still have one pending in Clinton County.
Do you have a domestic violence pending?
No.
Do you have another assaultive crime pending?
The papers I have here for it says obstructing justice, contempt, and yeah, that was the last thing I was PR'd on.
Okay, I have your criminal history here. It does indicate that you were bound over on a felony assault with intent to do great bodily harm, less than murder, or by strangulation in the 29th Circuit Court. It does not show that that was dismissed. It also shows that there was a domestic violence that accompanied that.
Then Yes, that's still it.
Yeah, but you didn't tell me the charge was it Mr. Bennett? 29 Circuit, is that? Clinton County? It should be Clinton County. Yep, okay. So when's your next court date on that?
5/22/24.
Okay, you can address bond counsel.
Thank you, Your Honor. Mr. Harris is a father of two that are living in his home. He works 2 jobs to help support his family at Great Lakes Janitorial and Meyer Warehouse, as he has reported to the court. He is from the Lansing area and has extensive family here. So he's not a flight risk, Your Honor. We understand that the court will have concerns giving some of the current charges, and we ask the court to consider his status as a full-time employee and father in consideration of his bond, Your Honor.
Thank you. I appreciate that he has a status as a full-time employee and that a father, but he also has a status of being on bond in more than one court at this time with the new assaultive charge or charges being brought against him. And so for those reasons, the court believes there is a current threat to the public safety. Personal recognizance bond will not be appropriate. Bond will be set in the amount of 15,000, 10% with GPS tether. While out on bond, you're not to be within 1,500 feet of Rosalind Tucker. You're not to have contact directly or indirectly with Rosalind Tucker. Do you understand that?
Yes, ma'am.
You're not to possess a firearm or any other dangerous weapon. You're not to travel outside the state without prior approval of the court. You are not to use, purchase, or possess alcohol or drugs without a valid prescription. GPS tether is being ordered, and you need to report to pretrial services within 48 hours of your release. Do you have any questions about the no contact order or any other of your bond conditions?
No, Your Honor.
I can't hear you. It didn't pick up your voice.
No, Your Honor.
Any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
Thank you. You're all set, sir. The record in the matter of the people of the state of Michigan versus Anthony Vincent, file number 22-03018, FY, counsel appearance.
Assistant Public Defender John Lee appearing on behalf of Anthony Vincent.
Are you Anthony Vincent?
Yes, Your Honor.
Okay, Mr. Vincent, I have a felony complaint here. It alleges that on or about November 18, 2021 at Bailey Street at Baker Street, City of Lansing, Ingham County, State of Michigan, that you allegedly committed the act of controlled substance possession of methamphetamine or ecstasy, and that you did knowingly or intentionally possess methamphetamine contrary to MCL 333.74032B1. That's a felony. Maximum penalty is 10 years and or $15,000 in fines. You understand the charge, reading count 1 and maximum penalty?
I don't. I thought I was being charged with a misdemeanor.
Okay, I don't know why you thought you were being charged with a misdemeanor because it's definitely a felony, maximum penalty, 10 years in prison and or $15,000 in fines. Do you have any questions about the charge and the maximum penalty?
Oh, Your Honor.
Okay, you have the right to be represented by an attorney, and Mr. Lee was representing you today solely for the purpose of your arraignment. You have the right to have an attorney represent you at each stage of the criminal prosecution, and if you're questioned by law enforcement, if you can't afford to hire an attorney, you can make a request to have the public defender's office appointed at the expense of the public. Do you understand your right to counsel?
Yes, Your Honor.
Okay, you have the right to remain silent. Anything you say, anything you put in writing can be used against you. You can plead guilty, plead not guilty, or stand mute. If you stand mute, this matter will continue to a jury trial. You have the right to a preliminary examination because you are being charged with a felony. You have the right to have that preliminary examination within 21 days of today's date unless you waive that timeline or the court finds good cause to go beyond 21 days. You're scheduled for a probable cause conference before Judge Flores on Thursday, April 25th, 2024 at 8:30 in the morning. You can appear via Zoom for that. However, actually, no, you can't. It says in-person appearance is required. So you must appear in person for Judge Flores' probable cause conference on this matter. Preliminary examination is scheduled Thursday, May 2nd, 2024, 8:30. You must also appear in person for that. Do you understand?
Yes, Your Honor.
Okay, you have the right to require the prosecution at the time of your exam to establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime. You have the right to proceed all the way to a jury trial. At the time of your jury trial, you have the right to the presumption of innocence. You're innocent until proven guilty. You can require the prosecution prove your guilt at your jury trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to see, hear, or question in court any of the witnesses that the prosecution calls against you. You have the right to call your own witnesses or present evidence that you believe show a defense of the charge being brought against you. And you have the right to waive your right to silence at your trial and testify on your own behalf. You understand those rights?
Yes, Your Honor.
Is he requesting court appointed counsel?
Yes, he is, Your Honor.
Court will enter a plea of not guilty on your behalf. What's your home address?
1732 West Joliet Road, Lansing, Michigan, 48910.
Are you employed?
No, Your Honor.
Phone number?
517-326-9426.
Are you currently on probation or are you on parole?
No, Your Honor.
Do you have any other cases pending?
No, Your Honor.
I have that you have a current bench warrant in the 56A District Court for a retail fraud second. I also see here, it looks like you were bound over, it says, to the 29th Circuit Court on a controlled substance. You're saying that you don't have any other cases pending?
No, I got everything took care of, Your Honor.
So when did you take care of those?
I took care of was the 29th Circuit Court, was that at St. John's? I took care of
Yes.
that back in 2020. And then I took care of the retail fraud just yesterday over in Eaton County. I got fines and costs on that, Your Honor. I got dropped to retail fraud 3.
Okay, so you pled guilty on the retail fraud and you got fines and costs?
Yes, Your Honor.
Okay, and you turned yourself in on this matter?
Yes, Your Honor.
Counsel, you can address bond.
Thank you, Your Honor. A review of Mr. Vincent's criminal history includes some felony breaking and enterings back in the 1990s, early 2000s. Since that time, it appears that most of the charges that he has faced stem from substance abuse issues and crimes related to substance abuse. He doesn't pose as a risk or a threat necessarily to our society. He does have significant ties to the community. He's lived in Lansing most of his life, and all of his family is here. So he's definitely not a flight risk. We would ask the court to consider a personal recognizance bond for Mr. Vincent.
Yeah, Mr. Vincent turned himself in on this matter, so the court will continue with the presumption that he's not a flight risk. I don't see any recent, other than the retail fraud cases that are still open. I do see the 2021, it does not have, the 2020 case that is, that does not have a disposition in the system yet. I don't know why it still shows as being bound over. I don't see a disposition. Nonetheless, the court will grant the request for a personal recognizance bond. A bond will be set in the amount at 5,000 personal recognizance. While you're on bond, you need to report to all of your court dates. You're not to possess a firearm or any other dangerous weapon. You're not to use, purchase, or possess alcohol or drugs without a valid prescription. You're not to travel outside the state without approval of the court. And again, you need to report to all of your court dates if you want to continue with a PR bond. Do you understand that?
Yes, Your Honor.
Do you have any questions about your bond conditions?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing further, Your Honor.
Oh, don't forget to report to pretrial services within 48 hours.
Thank you. I will, Your Honor.
Thank you.
Thank you. You have
On
a
the
good day.
record, same to you, sir. On the record, in the matter of the people of the state of Michigan versus San Juan Palmer, I have file numbers 23-02363, 23-02-03254, and 15-03793. Counsel appearance.
Assistant Public Defender John Lee appearing on behalf of San Juan Palmer.
Are you San Juan Palmer?
Yes, Your Honor.
Okay, Mr. Palmer, I have a felony complaint in file number 23-02363. That complaint alleges that on or about on or about December 1st, 2022 at 1200 Block Paco Drive, City of Lansing, Ingham County, State of Michigan, that you allegedly committed the act in count 1 of controlled substance possession of cocaine, heroin, or other narcotic, less than 25 grams. The allegations state that you did knowingly or intentionally possess less than 25 grams of a mixture containing the controlled substance of cocaine, contrary to MCL 333.7403-2A5. Now that's a felony, maximum penalty 4 years and or $25,000 in fines. There's an habitual offender second offense notice. It says take notice that the defendant was previously convicted of a felony or an attempt to commit a felony in that on or about August 31st, 2016. He was convicted of the offense of child support failing to pay the violation of MCL 750.165 in the 30th Circuit Court of Ingham County, State of Michigan. And therefore, defendant is subject to the penalties provided by MCL 769.10, which increases the penalty to 1 1/2 times the maximum sentence on the primary offense or a lesser term. The maximum penalty cannot be less than the maximum term for the first conviction. Okay, file number 23-03254 is the City of Lansing versus San Juan, Larry Ryshawn Palmer. And that complaint alleges that on or about April 8th, 2023, that you did allegedly knowingly furnish a Lansing police officer with false information, that being an incorrect name, at or near the vicinity of South Martin Luther King Boulevard, Pierce Road, Lansing, Michigan, during the officer's investigation of a violation of state or local law or ordinance, and that this is contrary to the provisions of the Code of Lansing Ordinances, that being 602.03A. The maximum penalty in count 1, 90 days in jail and or $500 in fines. There's a count 2, alleging that you did transport in the passenger area of the motor vehicle an alcoholic beverage in an open, uncapped, or unsealed container within the passenger area of the vehicle, or at or vicinity, that's at or near the vicinity of South Martin Luther King Boulevard and Pierce Road, Lansing, Michigan, contrary to the provisions of the Michigan Vehicle Code, being 257.624A. Count 2, have a maximum penalty of 90 days in jail and or $500 in fines. Do you understand the charges read in both files and the maximum penalties that's attached to each of the charges in those files?
Yes, Your Honor.
Okay, you have the right to be represented by an attorney in each of these files, and Mr. Lee is going to represent you today for the purposes only of your arraignment. You have the right to have an attorney represent you at each stage of the criminal prosecution, and if you're questioned by law enforcement. If you can't afford to hire an attorney, you may make a request to have the public defender's office appointed at the expense of the public. Do you understand your right to counsel?
Yes, Your Honor.
You have the right to remain silent. Anything that you say and anything you put in writing can be used against you. You can plead guilty, you can plead not guilty, or you can stand mute. If you stand mute in each of these files, you'll proceed all the way through to a jury trial. You have the right to jury trial. However, in file number ending in 2363, you are being charged with a felony. So in that file, you have the right to a preliminary examination. You have the right to have that examination within 21 days of the date that you're arraigned. That's today's date. And that date will be 21 days unless you waive it or the court finds good cause to go beyond the 21 days. At the time of your preliminary examination, you have the right to require that the prosecution put forth sufficient evidence to establish probable cause that a crime was committed and probable cause to charge you with the crime that's being alleged, which is possession of cocaine. You're currently scheduled for a probable cause conference before Judge Stacia Buchanan. It's going to be Thursday, April 25th at 10 o'clock in the morning. You have a preliminary examination before Judge Buchanan. It's scheduled for May 2nd, 9 o'clock in the morning. You must appear in person for both of those court appearances. Do you understand that?
Yes, Your Honor.
The furnishing false information and open alcohol are currently scheduled for a pretrial conference before Judge Stacia Buchanan Tuesday, April 30th at 10 o'clock in the morning. In-person appearance is required. Do you understand that?
Yes, Your Honor.
Did you get a copy of the notices to appear for those court dates for Judge Buchanan?
Yes, Your Honor. Yes, Your Honor.
In each of these files, sir, you do have the right to the presumption of innocence. So that means you're innocent until proven guilty, and you can require the prosecutor to prove your guilt at a jury trial by proving each element of the charges being brought against you beyond a reasonable doubt. You have the right to see, hear, or question in court any witness that is called to testify against you, you have the right to remain silent at your trial and not have silence be used against you, or you can waive your right to silence and testify on your own behalf. You can subpoena witnesses that will testify for you at trial or present evidence that you believe show a defense to the charge being brought against you. You have the right again to require the prosecution prove each element of each of the charges being brought against you beyond a reasonable doubt. Do you have any questions about those rights?
No, Your Honor.
What's your home address?
4040 Waverly Place.
You said 4040 what?
Waverly Place.
Okay. Are you employed?
No, Your Honor.
What's your phone number?
313-808-1285. I mean, 803-1285. I'm sorry.
803-1285.
No, 808-1285. I'm tripping. I'm sorry.
Okay. Are you currently on probation or on parole?
No, Your Honor.
Do you have any other court cases pending?
No, Your Honor.
Now, Mr. Lee, is he requesting court-appointed counsel?
Yes, he is, Your Honor.
Or will enter a plea of not guilty on your behalf? Okay, people of the state of Michigan versus San Juan Palmer, file number 15-03793. This is in collections. It's a collections warrant because you owe $159.55. You were supposed to be on a payment plan back in 2018. Looks like you made one payment of $80.45. The court was gracious and set aside $285 additional fees that included late fees and such, but you still have a balance of $159.55. Are you paying that today?
No, Your Honor.
Excuse me?
I don't have it.
When are you gonna have it?
I don't have the money today.
I know, when are you gonna have it? Because it's almost 10 years and you still haven't had it.
I'll probably can have it in a couple days. Tomorrow, at the most.
Okay, I'll note here you'll pay in full by Friday.
Okay.
Okay, counsel, you can address bond on the other two matters.
Thank you, Your Honor. Mr. Palmer reports that he did have some prior contact with the criminal justice system. Only one crime that would be considered assaultive in nature, that would be a domestic violence in 2010. There were a couple of driving impaired or under the influence of alcohol offensives, and felony child support, as the court noted. But some of that is dated. He hasn't had any trouble in the last 10 years. He's been living here in the Lansing area since 1999. He lives with his girlfriend, and she has a lot of family in the area. He has some cousins in the area that he still spends time with. So he doesn't present as a flight risk, Your Honor. We would ask the court to consider a personal recognizance bond on Mr. Palmer's behalf.
Okay, bond in file number 2363 is going to be set at 5,000 personal recognizance. You need to appear at all of your court dates. You understand that?
Yes, Your Honor.
A bond in the open alcohol and the furnishing false information is set at 500 personal recognizance. In both files, you're not to use, purchase, or possess drugs or alcohol without a valid prescription. You're not to travel outside the state without prior approval of the court. You're not to possess a firearm or any other dangerous weapon. In the felony file, you must report to pretrial services within 48 hours of your release. Do you understand that?
Yes, Your Honor.
You have any questions about your bond conditions?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing further, Your Honor.
You're all set, sir. Don't forget to make your payment on the other file. Rebecca Watson here. No. You're all set, thank you.
Thank you.
We need a copy. Okay. On the record in the matter of the people of the state of Michigan versus Jamie Van Hoos, file number 24-00384. Counsel's appearance.
Assistant Public Defender John Lee appearing on behalf of Jamie Lynn Van Hoos.
Are you Jamie Lynn Van Hoos?
Yes, ma'am.
Okay, Ms. Van Hoos, today's the date that's up for an arraignment. This is for a felony that you were previously arraigned on. For controlled substance possession of cocaine, heroin, or other narcotic less than 25 grams occurring on or about February 12, 2024 at Mary Street and Martin Luther King Boulevard. Do you recall being arraigned on that?
Yes, ma'am.
Okay, at the time, you were supposed to have your preliminary examination and probable cause conference actually was scheduled for February 22nd at 9 a.m. The court received some indication that you were in custody at Clinton County. So the court writted you to have you brought over for your preliminary examination. However, on February 29th, we were notified that you were not in Clinton County Jail. You did not appear in court. What happened?
I forgot about it, ma'am.
You forgot about it?
Yeah.
Okay, what's your home address?
1360 Boy Shot Road, Lansing, Michigan, 48906.
Okay, your matter is gonna be rescheduled for probable cause conference before Judge Cynthia Ward, April 26, 2024, 9 o'clock in the morning. You're going to have a preliminary examination before Judge Ward. It's gonna be on May 3rd at 8:30 in the morning in person at the court. Did you get a copy of your notice to appear?
Yes, ma'am.
Counsel, you can address bond.
Thank you, Your Honor. Ms. Van Hoos, as she reports to the court, has been dealing with a lot of issues and trying to resolve all of her matters and get them put behind her. She would like to resume, something that resembles a more normal life, and ask the court to consider that she was previously granted a PR bond on this case, and intends to participate fully.
Ms. Van Hoos looks like she's had a long night and she can't keep her eyes open.
Yes, ma'am, I've been on this concrete floor.
You said what?
I've been on this concrete floor all night, ma'am.
Okay, I can recognize that. Are you currently under the influence of anything?
No, ma'am, I just been downtown all night.
Okay. Ms. Van Hoos doesn't keep up with her court dates, and so that is a concern for the court. We have a felony that's pending. I recognize you may have more than one thing going on, but the court's not responsible for babysitting you to make you remember your court dates. And you're an habitual offender, fourth offense notice is on here, which means that you have familiarity with the court and you know that you're supposed to appear in court for your court dates. Because you have an habitual offender notice, your maximum penalty on this is 15 years. You did previously have a 10,000 personal recognizance bond, but after your failure to appear because you forgot about it, the court does believe that the likelihood of Ms. Van Hoos returning on her own recognizance is low. For those reasons, bond will be set in the amount of 10,000, 10%. All previous bond conditions, including not using or possessing drugs or alcohol without a valid prescription, not traveling outside the state, not possessing a firearm or any other dangerous weapon, will be continued. The court is also going to remind Ms. Van Hoos she must report to pretrial services within 48 hours of her release. And I'm going to add that she needs to test weekly randomly, that is weekly, for drugs and alcohol. Do you have any questions about your bond conditions?
No, ma'am.
Any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
You're all set, Ms. Van Hoos. On the record in the matter of the people of the state of Michigan versus Demoya Berger, file number 24-01135, appearance for the record.
Assistant Public Defender John Lee appearing on behalf of Demoya Designee Berger.
Demoya Berger?
Yes, no.
Okay, Ms. Berger, I have a felony complaint here that alleges that on or about April 16, 2024 at 541 East Edgewood, City of Lansing, Ingham County, State of Michigan, that you did allegedly commit the act in count 1 of police officer assaulting, resisting, or obstructing. The allegations are that you did an assault, batter, wound, resist, obstruct, oppose, or endanger Officer Nicholas McKeevy, a police officer of the Lansing Police Department that the defendant knew or had reason to know was performing his duties contrary to MCL 750.81D1. This is a felony with the maximum penalty 2 years and/or $2,000 in fines, and a consecutive sentence may be imposed under the law if the assault was committed in a place of confinement. Do you understand the charge and the maximum penalty?
Yes, ma'am.
You have the right to be represented by counsel. Mr. Lee is representing you today for the purposes of your arraignment only, but you have the right to have an attorney represent you at each stage of the criminal prosecution and the right to have an attorney represent you if you're questioned by law enforcement. If you can't afford to hire an attorney, you can request to have the public defender's office appointed to represent you at the expense of the public. Do you understand your right to counsel?
Yes, Your Honor.
Okay, you have the right to plead guilty. You can plead not guilty or you can stand mute. If you stand mute, this matter will continue to a jury trial. You have the right to have a preliminary examination within 21 days of today's date unless you waive that 21-day timeline or the court finds good cause to go beyond the 21 days. You're currently scheduled to have a probable cause conference before Judge Tony Flores Thursday, April 25th, 2024 at 8:30 in the morning. You have a preliminary examination before Judge Flores. That's gonna be May 2nd, 2024 at 8:30 in the morning. You must appear in person for your preliminary examination, okay, ma'am?
Yes, ma'am.
Did you receive a copy of your notice to appear before Judge Flores and your Zoom instructions?
Yes, Your Honor.
You have the right to require the prosecution put forth evidence at the preliminary examination that established that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with those crimes. You have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecution prove your guilt at your jury trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to remain silent and not have silence be used against you at your trial. You have the right to confront in court your accusers and cross-examine them. You have the right to present evidence or testimony that you believe show a defense to the charge being brought against you. You can waive your right to silence at your trial and testify on your own behalf. Do you have any questions about those rights?
No, Your Honor.
Is she requesting court-appointed counsel?
Yes, she is, Your Honor.
The court will enter a plea of not guilty on your behalf. What's your home address?
645 West Willow Street, Arraignments 207, 48906.
Is it apartment 207?
Yes, Your Honor.
Okay, are you employed?
Yes, ma'am.
Where are you employed?
Work 2 jobs. I work for Lansing School District at Mount Hope.
What do you
And
do
I
for
work
Lansing
as my
School District?
lunch assistant.
And you work where else?
I work at Myers Warehouse, distribute.
What's your phone number?
517-214-7281.
Are you on probation or parole right now?
Ma'am.
Mr. Lee, you can address the court.
Thank you, Your Honor. Ms. Berger reports no adult convictions of any kind. She says that when she has been involved with the criminal justice system of the court, she has always appeared and participated in the process. She has lived here in the Lansing area her whole life, has many family and friends here in the area for support. We believe that she will participate in the process and see this matter through to the end, Your Honor. We're asking for a personal recognizance bond on Ms. Berger's behalf.
I don't see any adult criminal history noted, only some matters that were juvenile adjudicated. Let's see. Bond will be set in the amount of 1,000 personal recognizance with the following conditions. You're not to travel outside the state without prior approval of the court. You're not to engage in assaultive or threatening behavior. You're not to use, purchase, or possess alcohol or drugs without a valid prescription. You are not to possess a firearm or any other dangerous weapon, and you must report to pretrial services within 48 hours of your release, and you must report to all of your court dates. Do you have any questions about your bond condition?
Oh, Your Honor.
Any additional matters for the record, counsel?
Nothing further, Your Honor.
Here, you're all set.
Thank you, Your Honor.
Thank you.
You go.
On the record in the matter of Amanda Wheeler. People of the state of Michigan versus Amanda Wheeler, I have file numbers 24-00150. I also have 24-01142. Counsel appearance.
Assistant Public Defender John Lee on behalf of Amanda Wheeler.
Amanda Wheeler.
Yes.
Okay, Ms. Wheeler, I have two separate files for you. File number ending in 142. Have a felony complaint that alleges that on or about April 16, 2024 at 560 Norman Street, City of Lansing, Ingham County, State of Michigan, that you allegedly, contrary to law, committed the act in count 1 of weapons carrying concealed. The allegations, ma'am, are that you did carry a dangerous weapon, that being a pistol, whether concealed or otherwise, in a vehicle operated or occupied by said defendant, that vehicle being a Chevrolet Silverado, contrary to MCL 750.227. Count 1 is a felony with the maximum penalty, 5 years in prison or $2,500 in fines. There's a mandatory forfeiture of the weapon or device required under the law. File number ending. Oh, wait a minute. What's this file? Oh, we'll do that one later. Do you understand the charge in that matter and the maximum penalty? Can you repeat it because there was a delay?
Yes.
Okay. You have the right to be represented by an attorney. Mr. Lee is going to represent you today for your arraignment. If you'd like to have counsel appointed at the expense of the public, you have the right to make a request for that appointment if you can't afford to hire an attorney. You understand your right to counsel? Try again, we can't hear you.
Yes, I do.
Okay.
My voice went away.
Yeah, there's always somewhat of a delay because it is being broadcasted virtually. So if your voice is low, it won't pick it up, okay?
Okay, is that better?
That's better, thank you. Okay, you have the right in this matter to have a preliminary examination because you're being charged with a felony. You have the right to have a preliminary examination within 21 days of today's date. You have the right to require the prosecutor put forth sufficient evidence that would establish that they have probable cause that a crime was committed and probable cause sufficient to charge you with the crime of carrying a concealed weapon. That 21-day timeline is yours by right unless you waive that timeline or the court finds good cause to go beyond the 21 days. You're currently scheduled for probable cause conference before Judge Cynthia Ward. It's going to be April 26th at 9 o'clock in the morning. Preliminary examination will be before Judge Ward, May 3rd, 2024 at 9:30 in the morning. You must appear in person for the preliminary examination. Did you get your notice to appear for Judge Ward for your probable cause conference and your preliminary examination?
I did not. I didn't get it, anything through the mail. So I was confused on the date and I had.
I'm sorry, you would have gotten that today in the jail.
Yes.
Okay, and it's for those dates that I just read?
Yes.
Oh, okay, very good. And you understand your right to have a probable cause conference and a preliminary examination, correct?
Yeah.
Okay, in this matter, you have the right to remain silent and not have silence be used against you. Anything that you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute, but if you stand mute, the matter will go all the way through to a jury trial. You have the right to a jury trial, and you have the right to the presumption of innocence at your trial. You have the right to require the prosecutor prove each element of the charge of carrying a concealed weapon beyond a reasonable doubt. You have the right to confront in court any of your accusers and cross-examine them. You have the right to testify on your own behalf, or you can invoke your right to silence and not have silence be used against you at your trial. You also have the right to subpoena witnesses to testify on your behalf at your trial or present evidence that you believe show a defense to the charge being brought against you. Do you have any questions about those rights? Is she requesting court-appointed counsel, Mr. Lee?
Yes, she is, Your Honor.
The court will enter a plea of not guilty on your behalf. What's your home address?
560 Norman Street, Lansing, Michigan, 48910.
560 what?
Norman, Norman Street.
Are you employed?
No, I'm not.
What's your phone number?
517-215-8383.
Are you currently on probation or on parole?
I'm awaiting sentencing, and my next court date for that is on 6/13/2024. And I already took a.
Excuse me?
I already took a plea with that. We're just waiting. I'm waiting sentencing so I can plead to that.
Okay. Have you ever missed court in the past?
One time, and I've only been to court here in Michigan one time, I believe. It was a miscommunication. I didn't get the paper in the mail, and I had relapsed, and my rehab was coming to come get me.
You didn't get the paper in the mail, and what happened?
So I was confused about the date. I had reported to the probation officer, and he never got back a hold of me until after the court date.
Why would the probation officer need to get back in touch with you?
Because I was confused about the date, because I didn't.
Okay, so you were confused about the date. What did you do to get clarity about that confusion?
I called him, and then that was all I did. I didn't know to do anything else.
Okay.
I tried calling.
So you were before the court back on February 2nd, 2024, and file number 24-00150. Is that correct?
Yes.
And Judge Ward took a plea from you.
Yes.
Is that correct?
Yeah, we haven't
answer my questions. Answer my questions and stop trying to tell me what you want me to believe, okay? I'm going to determine what I believe, not what you want me to believe, okay? Judge Ward gave you your court date that day, didn't she? I don't hear head nods.
Yes.
Okay. What was the confusion?
I lost the papers I got from the jail, and I didn't know where anything was because I was in between going from my grandma's to my mom because my mom has cancer, so I take care of her.
Okay. So I don't know why you keep saying you lost the papers from the jail. You would You were given the date and the time from Judge Ward. And
Yes,
if you lost the paperwork with that date and time, did you call Judge Ward's courtroom to find out what the date was?
No, I did not.
Okay,
No.
so then you didn't make any reasonable effort to find out what your court date was?
Okay, no, I guess not.
Is that
I guess-
correct? Do
I
you
guess
have an
not.
attorney? Do you have an attorney on that matter?
I don't know. I don't know if I do or if I don't. See, I talked to somebody in the jail and that was it. And then I
You don't,
never,
you took a plea and you didn't have an attorney that appeared on your behalf?
I had an attorney in the courtroom, but I didn't know if he was like assigned to me or,
You requested court-appointed counsel on that matter?
yes, I believe so.
You appeared for a probable cause conference and you were represented by Mr. Etheridge, were you not?
Yeah, by two different people. This one showed up at the next court hearing, and one was at the first one.
Okay, so you recognize you had two separate attorneys appear for you then, correct?
Yes,
Did you call the public defender's office to find out what your court date was since they were representing you?
yes, I did. I did call and leave them a message. Yes, I did.
Oh, okay, because you just told me you wasn't sure if you had an attorney or not.
Well, I called, that's what my, the secretary, the probation officer told me to do was call the public defender's office and try and get a hold of them. Cause I couldn't get a hold of.
Your matter's reset to go before Judge Ward for sentencing June 13th at 8:30. And you must appear in person.
Okay. I'm sorry.
Counsel, you can address the bond.
Thank you, Your Honor. In regard to Miss Wheeler's criminal history, she has a limited criminal history. The charge she just recently pled to and a driving while license suspended in 2020. She is a lifelong resident here of Lansing, Michigan. And we hope, as well as the court does, I'm sure, that she understands the importance of her attending her court dates, especially after the court's admonishment. We leave it in the court's discretion as to what sort of bond the court wants to set in this matter.
Can I get our bond back or how does that work?
Excuse me? Excuse me?
Nothing.
I can't hear you. Are you talking to me?
No, I was never mind. I'm sorry. I didn't know. I was trying to understand what he was saying.
Did you meet with someone from pretrial services today?
And I met with one person, that was it.
Do you know who
No,
you met with? It wasn't
no.
pretrial services?
And no. I don't believe so.
Okay,
I can meet with
think,
pre-trial services, okay?
well, no, I have a report. It was dated for today. It indicated that they attempted to meet with you for your pre-trial interview, and that you fell asleep during the questioning.
Oh, no, that wasn't me. No, that was not me.
No, it wasn't.
No,
Do you have children?
yes, I have 5 boys.
Your grandmother's name is Darlene?
Yep,
Okay, it was you.
I'm sorry, I didn't hear you.
It was you. You don't remember meeting with pre-trial services today?
No, not this morning, no. I've been in jail all night long. I've been in jail.
I recognize you were in jail. That's why they were meeting with you. Nonetheless, I do have a concern about her confusion. And she seems to be a little bit confused about why she missed her other court date or what her responsibilities were as it relates to that. She doesn't even remember meeting with pre-trial services, but they indicated that she fell asleep while they were questioning her about her employment, so they weren't able to complete the report and give a bond recommendation. But there is a bond recommendation from the prosecutor's office. Indicates that the defendant is currently on parole, probation, or has another pending criminal matter. The crime charged in this new case involves the use or possession of a firearm. Other factors that are that the prosecution wants the court to consider as an escalation of violence or risk taking over time. The people are requesting a $20,000 cash surety bond with GPS tether to minimize flight risk. Defendant is on bond before this court, 54A District Court, and failed to appear for a sentencing. While the charge before the court today does not include any assaultive or threatening nature, the allegations include defendant having recently threatened family members who reported that she possessed guns and often sells drugs. She's already out on bond when allegedly having committed the actions, now bringing her before the court for an arraignment. Considering the factors indicated or brought forth by the prosecution's bond recommendation, the court does believe that it's inappropriate to issue a bond in the personal recognizance, so that will be denied. Bond in this matter will be set in the amount of $10,000 cash surety. While out on bond, you have the following bond conditions. You're not to use, purchase, or possess a firearm or any other dangerous weapon. You're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess drugs or alcohol unless you have a valid prescription. You're not to travel outside the state without prior approval of the court. You need to report to all of your court dates and report on time, and you need to report to pretrial services. Within 48 hours of your release, you can get contact information from the jail as to how you make your report for that. Do you have any questions about your bond?
No.
Any additional matters for the record, counsel?
Nothing further. Thank you, Your Honor.
Actually, let me see something. I need to issue a bond on the file number 24-00150 that she needs to see Judge Ward on.
So I do have a question. So does that mean I have to say?
Give me a moment. Bond in file number 24-00150 is set at $5,010%. Okay, do you have a question now?
So does that mean I have to sit in jail until June?
Absolutely not. I gave you, does not mean that. You have bonds on both of those. It means you have to post the bonds before you can be released.
And if I can't post a bond, I'll have to stay in court until June 30th?
If you can't post a bond, then you get to sit there, but that's not the court. The court doesn't place the bond, so you have the ability to be released. You just have to post the bond, and that's considering the factors that the court put on the record. You have another matter pending that you have failed to appear in court on. You have another matter pending which bond conditions would have required you not to be in possession of a firearm. Now there's allegations that while that matter was pending and after you missed court, you were in possession of a firearm, and that these firearms were discovered after an investigation was launched due to calls of a family friend or otherwise individual reporting that you had threatened to use a firearm against them. And so for those reasons, and of course, the court had concerns about your responses as it relates to you falling asleep during the interview today. You don't even remember talking to the pretrial service person while in the custody of jail.
All the questions.
But, okay, you're cutting me off, so you're all set. Thank you.
Thank you.
The record back ahead.
On the record, in the matter of Sonny Rounds, file number 24-01143FY. Council appearance.
Assistant Public Defender John Lee appearing on behalf of Sonny Lee Rounds.
Okay, you're Sonny Rounds.
I am.
You can step forward, please. Okay. Mr. Rounds, today is the date that's scheduled for an arraignment, and I have a felony complaint here. The allegations are that on or about April 16, 2024 at 560 Norman Street, City of Lansing, Ingham County, State of Michigan, that you did allegedly, in count 1, commit the act of controlled substance possession of methamphetamine or ecstasy. The allegations are that you did knowingly or intentionally, possess methamphetamine contrary to MCL 333.74032BI. Count 1 is a felony. Maximum penalty is 10 years in prison and or $15,000 in fines. However, there is a habitual offender fourth offense notice. It says take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies in that on or about February 29, 2008, he was convicted of the offense of police officer assaulting, resisting, obstructing in violation of MCL 750.81D1 in the 35th Circuit Court of Shiawassee County, State of Michigan. And that on or about January 21st, 2011, he was convicted of the offense of breaking and entering a building with intent in violation of MCL 750.110 in the 56th Circuit Court of Eaton County, State of Michigan. And that on or about May 14th, 2012, he was convicted of the offense of possession of methamphetamine in violation of MCL 333.7403B1A in the 29th Circuit Court for Clinton County, State of Michigan. And that on or about October 28th, 2024, he was convicted of the offense of felonious assault in violation of Michigan Compound Law 750.82 in the 56th Circuit Court of Eaton County, State of Michigan, and therefore the defendant is subject to the penalties under MCL 769.12. That enhances the penalty in count 1 to life if the maximum penalty was 5 years or more, or 15 years or less if the primary offense has a penalty under 5 years. Your primary offense, again, is a penalty 10 years, so with the habitual fourth offense notice, it has enhanced your penalty to life if convicted. You understand the charge and the maximum penalty attached?
Pretty much.
Okay. You have the right to be represented by counsel. Mr. Lee is representing you today for the purposes of your arraignment, but you do have the right to have an attorney represent you at each stage of the criminal prosecution, and you have the right to have an attorney represent you if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the public defender's office appointed at the expense of the public. Do you understand your right to counsel, sir?
Yes.
You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue to your jury trial. You're being charged with a felony, so you have the right to have a preliminary examination, and you have the right to have it within 21 days of today's date. You have the right to require the prosecution put forth evidence that would establish sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime of controlled substance possession. You're currently scheduled for a probable cause conference before Judge Cynthia Ward. It's going to be on April 26, 2024 at 9 o'clock in the morning. You have a preliminary examination before Judge Ward Friday, May 3rd at 9:30 in the morning. You must appear in person for the preliminary examination. Again, you have the right to have that exam within 21 days of today's date unless you waive the timeline for the 21 days or the court finds good cause to go beyond the 21 days. Do you have any questions about those rights so far?
No,
You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty. You can plead not guilty or you can stand mute. You have the right to confront in court at the time of your trial any of the accusers or witnesses called to testify against you. You have the right to the presumption of innocence, so you have the right to require the prosecutor prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. You can remain silent at trial and not have silence be used against you. You can waive your right to silence and testify on your own behalf or subpoena witnesses that you would like to testify or present evidence at your trial that you believe show a defense to the charge being brought against you. Do you have any questions about those rights?
not right now.
Okay, Mr. Lee, is he requesting court-appointed counsel?
Yes, he is, Your Honor.
The court will enter a plea of not guilty on your behalf. What's your home address?
6852 Gildart Road, Eaton Rapids, Michigan. 4827.
Is there an apartment?
Apartment 2.
What city?
Eaton Rapids.
Are you employed?
Yes.
Where?
Current. Eaton Rapids.
Where in Eaton Rapids?
Charles Gatlin Builders.
Yes. What's your phone number?
517-588-1572.
Are you currently on probation or on parole?
No,
Do you have any other court dates pending at this time? Okay, you were on probation, it looks like last in Eaton County, is that correct?
I believe so.
You don't remember?
I said I believe so. I believe that's
Yeah, I know
right,
you said-
correct?
Okay, were you discharged from that probation?
Yes.
Okay.
No longer on any kind of probation or anything.
Counsel, you can address bond.
Thank you, Your Honor. Mr. Rounds has advised me that he intends to participate in this matter fully, that he has always participated and showed up for court whenever the court has asked him to. He has lived here in the Lansing area his whole life. He has extensive family in the area as a support structure. As this is a nonviolent crime, we're asking the court to consider a personal recognizance bond on his behalf.
Okay, bond is set in the amount of 10,000 personal recognizance with the following conditions. You need to report to all of your court dates. Excuse me? Do you have a question?
Can I get my bond lowered?
I just gave you a personal recognizance. What do you want me to do?
I don't know what does that mean?
Well, someone with a lengthy criminal history like you should know exactly what a personal recognizance bond is.
It's been years since, 10 grand.
It
you
wasn't
said
that,
10,
you just got off probation a couple months ago.
no, a couple, really? Okay.
Personal recognizance means you don't have to pay anything to get out of jail.
Oh. So why is there a $10,000?
I'll let your attorney explain any of those questions to you at this point. Again, following conditions. You are not to use, purchase, or possess drugs or alcohol while out on bond. You will be tested for drugs and alcohol 1 time a week. You need to report to all of your court dates. You need to report to pretrial services within 48 hours of your release. You're not to possess a firearm or any other dangerous weapon. You're not to travel outside the state without prior approval of the court. Do you have any questions about your bond conditions?
No.
Any additional matters for the record, counsel?
Nothing further, Your Honor.
You're all set, sir. On the record, in the matter of the people of the state of Michigan versus Troy Ruff, file number 24-01104. I'm sorry, 24-01144, counsel appearance.
Thank you, Your Honor. Assistant Public Defender John Lee appearing on behalf of Troy Ruff.
You're Troy Ruff?
That's me.
Okay. Looks like this is the co-defendant. I have a felony complaint here alleges that on or about April 16, 2024, at 560 Norman Street, City of Lansing, Ingham County, State of Michigan, that you allegedly, contrary to law, committed the act in count 1 of controlled substance possession of methamphetamine, and that you did allegedly, knowingly or intentionally possess methamphetamine contrary to MCL 333.74032 BI. Count 1 is a felony. The maximum penalty is 10 years and or $15,000. However, there's an habitual offender 4th offense notice. It says, take notice that the defendant was previously convicted of 3 or more felonies or attempts to commit felonies. And that on or about October 3rd, 2000, he was convicted of the offense of operating while intoxicated, 3rd offense, in violation of MTL 257.6256D in the 30th Circuit Court for Ingham County. And that on or about December 12, 2007, he was convicted of the offense of forgery in violation of MTL 750.248 in the 30th Circuit Court for Ingham County, State of Michigan. And that on or about August 8, 2012, he was convicted of the offense of home invasion, 2nd degree, in violation of MCL 750.110A3 in the 30th Circuit Court for Ingham County, State of Michigan. And therefore, the defendant is subject to penalties provided by MCL 769.12 that enhances your penalty in count 1 to life, because the maximum penalty is 5 years or more in count 1. Do you understand the charge of the maximum penalty?
Yes, I do.
Okay, you have the right to counsel. Mr. Lee's going to represent you today, but you have the right to have an attorney represent you at each stage of the criminal prosecution, and you have the right to have an attorney represent you if you're questioned by law enforcement. If you can't afford to hire an attorney, you can request to have the public defender's office appointed at the expense of the public. Do you understand your right to counsel?
Yes, ma'am.
You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue to trial. You have the right to preliminary examination because you're being charged with a felony. You have the right to have that prelim within 21 days of today's date unless you waive the timeline or unless the court finds good cause to go beyond the 21 days. You have the right to require the prosecution establish that they have sufficient probable cause that a crime was committed and probable cause sufficient to charge you with the crime at the time of your preliminary examination. You're scheduled to be before Judge Cynthia Ward for a probable cause conference, April 26, 2024 at 9 o'clock in the morning. You have a preliminary examination on April 3rd, 2023 at 9:30, and you must appear in person. Do you understand that?
Yes, ma'am.
You got a copy of your notice to appear and Zoom instructions for Judge Ward, is that correct?
Yes, ma'am.
Again, you have the right to the presumption of innocence. So that means that you're innocent until proven guilty, and you have the right to require the prosecutor prove your guilt at trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to see, hear, or question in court any of your accusers, and you have the right to call witnesses or present evidence that you believe show a defense to the charge being brought against you. You can invoke your right to remain silent in trial or waive that right and testify on your own behalf if you'd like. But again, you have the right to require the prosecutor prove your guilt beyond a reasonable doubt at your jury trial. Do you have any questions about those rights?
No, ma'am.
Is he requesting court-appointed counsel?
Yes, he is, Your Honor.
Okay, the court will note that on the file and enter a not guilty plea on his behalf. Sir, what's your home address?
9301 Riverside Drive, Rattle Edge.
Are you employed?
No, ma'am. I was laid off.
You're laid off from where, sir?
Tenant Pontoon.
Okay. What's your phone number?
517-899-5415.
Your voice was a little low. What's the last 4 digits?
5415.
Are you currently on probation or on parole?
No, ma'am.
Do you have any other court dates pending?
No, ma'am.
Counsel, you can address bond.
Thank you, Your Honor. Mr. Ruff has been a lifelong resident here in Lansing. He has extensive family in the area and currently, in fact, lives with his family and has advised me that he intends to participate in this process. We understand that he does have some prior felony convictions, but this is not a violent crime. So we're asking if the court would consider a personal recognizance bond on Mr. Ruff's behalf.
Thank you. Our bond will be granted a personal recognizance. It's 10,000 personal recognizance with the following conditions. You must report to pretrial services within 48 hours of your release. You're ordered to test for drugs and alcohol 1 time per week. You're not to possess or use drugs or alcohol unless you have a valid prescription. You're not to travel outside the state without prior approval of the court. You're not to possess a firearm or any other dangerous weapon. Do you have any questions about your bond conditions?
No, ma'am.
Any additional matters for the record, counsel?
Nothing further, Your Honor.
Thank you. You're all set, sir.
Thank you.
Your Honor, Mr. Rupp might have a second packet 2 or 3 below that on an old civil FTA. I think they might have gotten separated today.
Oh, okay, I see it on the second page. Let me see. Thank you. Let me find the file. Well, this is old. Okay, this is, who is this? Lansing Automakers Federal Credit Union versus Troy Ruff, file number 06-00649GC. And this is in warrant status because you were supposed to be before the court on a creditor's exam after a civil judgment, and you failed to appear. What was your address again, sir?
9301 Riverside Drive, Grand Ledge,
Okay,
Michigan.
okay, so you were notified properly because that's the address on this file. Looks like there is a.
What date was that, ma'am? Do you know?
My apologies, Zoom will kick you out after you've been on there too long. Okay, can you hear me now?
Yes, ma'am.
Okay, it looks like you were supposed to be before Judge Ward on a creditor's exam back on January 14th, 2020.
Oh. Okay.
And at the time, you owed a balance of $1,117.48. When you failed to appear for the exam, attorney for the plaintiff, which is LAFQ, requested a show cause and a bench warrant. And so, let's see here.
And that whole thing is like 7, 8, 10 years old.
It's more than that because the original case number it starts with an 06, so that indicates to me that this was filed in 2006. So almost 20 years old.
So
but I'm not following your point. Excuse me?
Doesn't that negate the debt?
No, if you're talking about the statute of limitation, the great state of Michigan allows them to file and extend the statute every 10 years, and apparently they've done that. And so you still owe this debt.
All right.
And so because you failed to appear or respond to their notices on this matter, even though you had the same exact address that they served you on 4 years ago in these matters, they're requesting that you must post a bond in this matter before being released on this matter. And so.
Here we go.
They're requesting a bond of $1,118.
Of course they are. Ma'am, I don't have any money for that.
Well, you're going to post a bond because you're not going to be returning on your own recognizance because you haven't returned to court on a civil matter, and a bond had to be issued after a bench warrant on a civil matter, which is ridiculous.
I didn't even, ma'am, I'm sorry. I was unaware of it.
Well, it was sent, multiple notices were sent to your house and you were served personally, it says, by a court officer.
And I was
at that address,
divorce.
so you were aware.
I was going through a divorce. I was getting lots of paperwork.
I recognize you were going through a divorce, but you were served at the address of 9301 Riverside Drive, December 13th, 2019 at 3 o'clock in the afternoon. Personal service was executed, so they handed it to you.
Okay.
Bond is set at $200 on this matter. I'm not going to require you to post the full amount, which is $1,118, but you will post $200 because I'm confident that you were aware that you had this civil matter and civil judgment pending and you ignored the notices. And so that matter will be reset for a hearing for a creditor's exam before Judge Ward, okay?
Yes, ma'am.
Give us a date. Let me give you a date on that. It's scheduled for May 15th at 8 o'clock in the morning. Did you get a notice to appear for that?
No, ma'am.
Okay, we'll make sure one is brought down to the jail then. You're all set, sir. People of the state of Michigan versus Prince Chilaka, file number 24-01104, council appearance.
Assistant Public Defender John Lee appearing on behalf of Prince Chilaka.
Okay, today's the date set for, let's see, a bond violation, also called a PA 53 pretrial release violation. And the allegations, Mr. Chilaka, are that you violated the conditions of your bond. You were placed on bond in this matter back on April 13th, 2024. So less than a week ago. And you had several conditions. One of those conditions were that you were not to enter into the following specified premises and not to be within 2,000 feet of the home, work, or school of Jade Bryant. And the allegations of that on or about April 16th, just 3 days after your arraignment at 7:21, that you allegedly violated those conditions. By being within the exclusion zones of the protected victim's work and home. So you have the right to have a contested hearing on the bond violations. You have the right to be represented by your attorney at that hearing. If you're found to be in violation of your bond conditions, your bond can be revoked. You could be sitting inside the jail until the domestic violence that's pending is resolved. You also could be sentenced for a contempt of court order, because when the court puts you on bond, you're under court order. And if you violate the bond, that's a contempt of court. And your maximum punishment for that is 93 days in jail and or $7,500 in fines. Do you understand that, sir?
Yes, ma'am.
You're on GPS tether right now?
Yes, ma'am.
Counsel, you can address the court.
Thank you, Your Honor. Mr. Chilaka is definitely going to participate in all of the aspects of the charges against him, including any hearings set on the PA 53 matter, Your Honor. He has pled not guilty today and looks forward to his day in court. We asked the court to consider reinstating his bond and giving him that opportunity. Thank you.
Thank you. The court has read the alleged allegations. I don't see where there was the allegations, I should say, were that indicated that he was possibly riding the bus within those exclusion zones. I don't think that there is a immediate threat. He is on GPS tether. He's not to be within 2,000 feet of the home, work, or school of Jade Bryant. the court thinks that the bond is sufficient to protect the victim at this time. So we'll continue the bond, 500 personal reconnaissance with GPS tether. I will remind you again of the no contact order, okay, sir?
Please.
Do you have any questions or concerns about that?
Does it mean that I get a PR or I pay money? I don't get it.
Well, you're already out on bond. I'm gonna continue your bond at this time. It's you have 500 personal recognizance with a no contact order, and you're not to be within 2,000 feet, okay?
Okay,
Thank you. You're all set, sir.
thank you.
Okay, that was on the record in the matter of the people of the state of Michigan versus Jesse Lincoln. Actually, that's probably people of the city of Lansing. People of the city of Lansing versus Jesse Lincoln, file number 24-01136. Appearance for the record.
Assistant Public Defender John Lee appearing on behalf of Jesse Lamas Lincoln.
Okay, you're Jesse Lincoln?
That's been.
Okay, Mr. Lincoln, in the first file, because I do have a few, you have a misdemeanor complaint, and it alleges that on or about April 16, 2024, that you did allegedly carry in the public place a knife having a blade of 3 inches in length, or over 3 inches in length, that being a knife over 3 inches at or near the address of 4200 South Pennsylvania, Lansing, Michigan, contrary to the provisions of the Code of Lansing being 696.04. Count 1, misdemeanor, maximum penalty is 90 days and or $500 in fines. Count 2, alleges that you did hinder, oppose, or obstruct or resist the Lansing police officer in the performance of law enforcement duties at or near 4200 South Pennsylvania, City of Lansing, Ingham County, State of Michigan, and that these were contrary to the provisions of the Code of Lansing being 602.02, maximum penalty, 90 days in jail and $500 in fines. Do you understand the charge read there and the maximum penalty?
Yes, ma'am.
You have the right to be represented by an attorney. Mr. Lee's representing you today, but you have the right to have an attorney represent you at each stage of the criminal prosecution, and you have the right to have an attorney represent you if you're questioned by law enforcement. If you can't afford to hire an attorney, you can make a request to have the public defender's office appointed to represent you at the expense of the public, okay?
Yes, ma'am.
You have the right to have a jury trial in this matter because you have the right to the presumption of innocence. So you can plead guilty, plead not guilty, or stand mute. If you stand mute again, your matter will continue all the way to a jury trial. You have the right to confront in court any of your accusers and cross-examine them. You have the right to waive your silence at trial and testify on your own behalf. You have the right to call witnesses to testify or present evidence that you believe show a defense of the charge being brought against you. Do you have any questions about those rights?
No.
Is he requesting court-appointed counsel?
Yes, he is, Your Honor.
Okay, the court will enter a plea of not guilty on your behalf. What's your home address?
4607 Ballard, Lansing, Michigan, 48911.
Are you employed?
No, ma'am.
How do you support yourself?
I do side jobs here and there whenever I can find them.
Why don't you have a job?
A couple years ago, my children's mother was murdered, and you know, I kind of got depressed, and you know, I've just been getting back into the shake of things and trying to rebuild with my kids.
What's your phone number?
956-269-0110.
People of the city of Lansing versus Jesse Lincoln, 21L2625520. You're $192. Of the city of Lansing versus Jesse Lincoln, 21L262550. You're $156. People of the city of Lansing versus Jesse Lincoln, 21L2625501. You owe $306. People of the city of Lansing versus Jesse Lincoln, file number 239. I'm sorry, the file number is actually 12-00290, and you owe $2,395.65. Are you paying that today?
No, ma'am.
Or when do you intend to pay these? And some of these are over 10 years old.
I can make a payment within the next probably week or two and set up payment arrangements, and you have my word, I'll stick to them.
Well, you've had payment arrangements and your word didn't assist us in any way. And I recognize that you experienced some loss, but I don't ever recall a loss being a reason why we don't work. And you have children that you need to take care of, and you've got a whole lot of bills, I'm sure, because I'm seeing how many bills you got in the court.
Yes, ma'am.
How much are you paying before you're released today?
How much do I need to pay? I don't have much money. I don't even have a way to get a hold of anybody right now.
Okay, well, I'm asking you how much you can afford to pay, because you got to make a payment on these.
I probably pay $20.
Okay. You'll pay $20 on the oldest file, which is file number from 12-00290. You'll also report to collections so that you can get on a payment plan on the other matters, okay?
Yeah.
Are you on probation or parole?
Oh, ma'am.
You're not.
Oh, ma'am.
Do you have any other matters pending?
Not that I'm aware of.
Oh, that's unfortunate. Let's see. I don't understand why you don't know that you're on bond right now, that you have a matter in the circuit court. Why don't you know that?
When you go to treatment on your own behalf or whatever, I went to the House of Commons. I left the House of Commons.
I didn't ask you if you went to treatment. I asked you, do you know that you got a pending case in the circuit court?
What's it for, ma'am?
Excuse me?
What is it for?
The 30th Circuit Court for possession of meth. Are you on GPS tether?
Oh, ma'am.
Looks like you were supposed to be on GPS tether, but maybe because you went to treatment, I'm not sure that was removed, but You have a matter that you actually have a bond violation for before the 30th Circuit Court. So I'm going to remand you to see the judge that that's before. It looks like you have multiple matters pending. You don't know that?
Oh, man.
You have a pending police officer assaulting, resisting, obstructing, and retail fraud first degree before the 56th District Court. You have a pending uttering and publishing before the 30th Circuit Court. You have a pending controlled substance possession of meth, which is the one I just told you that you're being remanded on before the 30th Circuit Court. You also have a pending controlled substance possession of meth. That's another file. That's not the one that I remanded you on. All before the 30th Circuit Court, and you're not aware of you having any court cases pending. Okay, counsel, did you want to address bond?
Your Honor, in regard to the misdemeanor city cases, we would ask the court to consider a 10% bond on Mr. Lincoln's behalf.
Bond will be set at 510% because the defendant does not appear in court when he's supposed to. He doesn't even remember when he asked for it, and he has 4 different felonies that are pending right now. And so those are things that typically people remember. Nonetheless, he's also remanded to see the circuit court judge on the new allegation of a bond violation. And once you're released, sir, you need to report to the court to pay your $20 on the 2012 file, and you must get on a payment plan on the remaining matters. Do you understand that?
Yeah.
Do you have any questions?
Oh, man.
You're all set.
Thank you.
Okay, let's see. One more. Okay, on the record in the matter of the people of the state of Michigan versus Angelita Vidal. This is file number 07-06254. Okay, you're Angelita Vidal?
Yes, ma'am.
Okay, Ms. Vidal, today's the date that was set because you were in bench warrant status on this matter. Do you know why?
I'm not sure. I believe it was an unpaid ticket.
Definitely not an unpaid ticket. You do owe money. You had operating while intoxicated. You pled guilty back in 2007. You were sentenced. I'm not finished. You were sentenced and you were supposed to pay a total fines, costs, and restitution, looks like $1,077. You were supposed to be making payments of $150 per month, beginning November 30th, 2023. So you, not too long ago, saw Judge Buchanan, and she revoked your probation on that because you had absconded and referred you to a payment plan on this. You didn't make any payments, so she set it for show cause. And consistent with the history of this case, which extends back to 2007, you failed to appear. And you owe a balance of $782. It looks like you did come in March 4th and you saw the magistrate. You said you thought this was taken care of. They again put you on a payment plan. You again made no payments.
I'm sorry,
Are you paying the $782 today?
I cannot pay it today. I guess I got confused because I'm doing another case right now. And I report to my probation officer every 2 weeks and
Ma'am, no way you got confused. This case has been pending for 2 decades, okay? No way you got confused. You saw the judge multiple times after you absconded, meaning you went AWOL. You were on probation, you never showed up. So finally you were picked up. She revoked your probation because of that and told you, she being Judge Buchanan, that you owe fines and costs and restitution. You've been told that since September 4 times already. You're not confused. You're paying something today or you're gonna sit in jail.
I can probably pay like $50 today.
When are you gonna pay the next payment?
In a week. I know I go
How
for
much?
sentencing on May 10th.
I'm not talking about your sentencing. I'm not dealing with any other file but this one that you've been owing money for restitution on since 2007.
Let's do $50 a week. I can do that.
You're gonna pay $50 today, and then you'll pay $50 per week until paid in full. The narrative that you're confused, that's not gonna work anymore. You gotta pay it so we can move on with our lives, okay?
Yes, ma'am.
Any additional questions today or statements that you want to make for the record?
No, ma'am.
Okay, you're all set.
You just sit down.
That's all I have.
Excellent. Thank you, Your
That's
Honor.
all.
Have a great evening.
Thank you all. Have a good one.
Thanks.